Your medical malpractice trial is almost over, and now, moments before the judge sends the jury out to begin deliberating, he turns to the extra jurors, the alternate jurors, and releases them and tells them that they're free to go. And you turn around to your attorney and say, hey, I want to talk to those alternate jurors, those extra jurors. I want to know what the jury was thinking before the jury actually goes back to deliberate. You think this is a good idea? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so now you sued your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. Your doctor denies all of your claims, and now you went through the entire litigation process. It took you 2 years to actually get to trial. And now you're finally at trial. Your trial takes 2 entire weeks. And now the attorneys have made their closing arguments. The judge has given the jury the law in your particular case. And then he explains the actual questions that the jury has to answer in sequence in order to reach a verdict in your case. In New York, there are 6 jurors who will be deciding whether you are slightly more likely right than wrong that what you are claiming is true. Now, what would happen if one of those main 6 jurors are now unable to continue during the entire 2-week trial? Well, now, if there were no extra jurors available, now you'd have to start the trial all over again, starting with a brand new jury. So in order to prevent that from happening, what the attorneys do during the course of jury selection is, after we pick the first 6 jurors, now we are told to pick some extra jurors. These are known, or what we call, alternate jurors. And they really participate the same exact way as the main jury. The main purpose of one of these alternate jurors is simply to fill the space of one of the main 6 jurors who is no longer able to continue. But what happens, though, if all 6 jurors have been there the entire duration and now they're ready to go back and deliberate? Well, at that point, the judge turns to those extra jurors and says, ladies and gentlemen, thank you so much for your jury service. But since all 6 of those main jurors have been here throughout the entire time, and now they will be the ones to go and deliberate, you are now released from jury duty with the thanks of the court. And now those 2 or 3 or 4 extra jurors can get up and leave. They can go ahead and talk to you. You can talk to them, assuming, of course, they want to talk to you. But they're free to go. They're free to stay. They're free to hang out. They can do anything they want at that point. But you get this idea in your head, hey, I want to talk to those extra jurors to see what they were thinking, to give you an insight about whether or not you're going to win your case. Is this a great idea? I'll tell you right now, it's a terrible idea. It's not a good idea at all. And you might be wondering, why is that? Why is it such a bad idea? They were sitting there listening to the testimony. Why wouldn't you want to go ahead and get their thoughts, their opinions? I'll tell you why. During the entire course of the trial, the judge is going to remind the jury during every single break at the end of every day. He's going to tell them, ladies and gentlemen, you are not to discuss this case, this testimony, the facts of this case amongst yourselves at all. Don't discuss it with anybody outside the courtroom. The only time you are permitted to begin talking about this case is when you go back to the jury deliberations room. After you hear closing arguments, after I have given you the law, after you are told what questions you must answer. That is the only time you are permitted to begin discussing amongst yourselves exactly what you think and why. So now, those extra jurors, those alternate jurors who have now been released, they are not participating in the jury deliberations. They don't know what the other jurors are thinking. All they know is what they're thinking, what their feelings are, what they thought about the testimony and the evidence that's gone on in your case. And you know what? Asking them questions about what they think after they've been released is meaningless. It doesn't matter what they think. It doesn't matter because they have not shared that information, at least they're not supposed to share it, with those other jurors. And assuming they lived up to their promise and did not discuss the facts of your case with the other fellow jurors, well, guess what? Just talking to them and getting some sense of what they think is not going to help you predict the outcome of your particular case. So from that standpoint, I'd say it's a terrible idea. Don't bother. Don't waste your time. So why do I share this quick information with you? I share it with you just to give you a sense of what goes on in these medical malpractice cases here in New York. You know, I do recognize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need to be answered, What I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.